Good morning. Thank you very much for joining us today when we're looking at important changes to right to rent. We've had, for what was a limited time period for people to sign up, over 500 people have done so. So we're just going to give it a couple of moments as the room fills. This webinar is scheduled for 45 minutes and we will allow time at the end for questions, and we would encourage you to get in touch, and I'll say more about that in a moment. For those of you who've previously been on one of our webinars, this will all be known to you. For people who are attending for the first time, welcome. Thank you very much for joining us. You're in mute mode by default, and that's so that other participants in the webinar aren't distracted by background noise, but we do want to hear from you. So if you have any questions, comments, thoughts, or anything else you would like to share with us, please do so via your GoToWebinar control panel, which is available on the right-hand side of your screen and looks a little like the display that I've got up there today. As I mentioned today, we are talking about important changes to right to rent, some of them COVID related, some of them not. But for everybody who is renting out properties in England, and just as a reminder, this relates to England only, there'll be some profound changes that you should be aware of. As always, today's content is for general information purposes. It shouldn't be taken as and shouldn't be construed as legal advice or official guidance, although one of our panelists, David Smith, who will introduce himself shortly, I'm sure would love to hear from you if you want guidance and advice on your specific legal facts and scenario through his law firm, JMW Solicitors. And so thank you very much to you all for joining, and thank you very much to our guests. I'd like you to introduce yourself if you'd be happy to. So Gareth, over to you.
Good morning, ladies and gentlemen. My name's Gareth Fowler. I'm the MD at Keysafe. That's my day job. Over the years, I've become involved in right to rent, more specifically talking training with agents regarding documentation, how to look at passports, how to spot fake passports, etc.
Brilliant. Thank you very much for joining us today, Gareth, and for sharing your insights and expertise. And David.
You're welcome.
Hi, my name's David Smith. I'm a partner at JMW Solicitors in London. I specialise in residential landlord and tenant law, and particularly regulatory aspects of it, and I've been talking about right to rent since it was first introduced, and as Gareth was cheerfully reminding me, I've also been involved in judicial reviews over its potential discriminatory nature.
Thank you, David, and thank you very much for joining us today. So we're going to, the topics we're going to cover off are on screen, and just again, if you have any questions as we go through, please do ask them via the GoToWebinar control panel, and my colleague Remy will be moderating the questions and we'll get through as many of the topics as possible. So just to make sure that we're all on the same page from a starting perspective, Gareth, could you give us a brief introduction to what is right to rent? What's the background? What is it?
Certainly, sure. In its very basic sense, right to rent is a piece of legislation. It requires landlords and by agreement letting agents to determine whether tenants and occupants have the right to live in the UK legally. With a few limited exceptions, it applies to all tenancies and occupants over the age of 18. As most of you will know, it's primarily a document checking exercise. The determination is made by checking ID documents. Dependent on nationality, an individual will either have a permanent or a time-limited right to rent in the UK. And for those with a time-limited right, follow-ups need to be made, follow-up checks need to be made, either within 12 months or at the end of the individual's time-limited right, whichever is the greater. A few important dates to go through. I'll literally whistle through these. I mean, we started with this in 2014. A lot of you remember December the 1st, 2014, the pilot scheme commenced in the West Midlands. So Wolverhampton, Birmingham, Walsall, Sandwell, Dudley was where the government randomly decided to carry out the pilot scheme. And despite quite a lot of criticism and not a lot of feedback, it was deemed to be a success, and it was rolled out throughout England on the 1st of February 2016. Those are the two key dates. Since then, there have been a few other things that have been either haphazardly announced or have been enshrined into legislation. March 2016, the Home Office and Arla announced that special rules had been agreed for military personnel and trusted travellers. Key date, December the 1st, 2016, we saw new criminal offences were added with a maximum penalty of up to 5 years in prison. And I think at the same time, hugely controversial, massive new eviction powers were triggered by service of a notice from the Secretary of State, which I know was something that nobody had seen before in the private rented sector. You could evict a tenant without going to, essentially without going to court. September 2017, Arla and the Home Office jointly announced special dispensation for students. There was always a concern with letting agents that student lets were traditionally agreed way outside of the 28-day period that right to rent checks have to be carried out. So we saw a special dispensation for that. Something that David alluded to a few seconds ago, March the 1st, 2019, the High Court ruled that the right to rent scheme was discriminatory and actually violated the European Convention on Human Rights. That was subsequently overturned on the 21st of April of this year. And I think the Court of Appeal, whilst acknowledging that it was actually discriminatory, gave the scheme the green light, and so it's carried on. And of course, March 2020, this year, we saw arrangements being put in place for because of COVID-19, where checks could be carried out, let's call it remotely, rather than face to face. So those are the few of the key dates and where we've come to and where we are at the moment.
That is absolutely brilliant. So thank you so much for your succinct and accurate summary of about 6 years of changes to right to rent in about 3 minutes. And hopefully that means that everybody's in the same starting place as we enter into looking at some of the changes. Moving on to the changes. So what are the COVID-related changes to right to rent? David, would you like to kick us off with that, please?
Sure. So a few months back now, when COVID started to kick off, the government made some changes to the right to rent on a temporary basis. Now there's some question about the legality of these changes, but for the 30th of March, they basically said that they don't mind if you do the following. So they won't prosecute or serve civil penalties if you do the following. And these changes continue in effect until some putative future date, which has not yet been announced, but they will give notice of. But the current position is that if you're doing a check, you're supposed to do it either face-to-face or holding the actual document in your hand and then the prospective tenant down a video link. During COVID, what you can do is do everything over video if you wish. So the tenant can hold up their document to the video camera and wave it at you, and you can then look at them, and then they must also send you a copy of the document electronically, and that is a satisfactory check, and you must endorse that document as having been checked using the adjusted procedure on a specific date. What you will then need to do is, when the Home Office decides this process has come to an end, when presumably we have a vaccine and Donald Trump is right and all of COVID has disappeared as if by magic, then you will get an 8-week time period to go back and redo these checks and do them in the conventional way, so face to face or with the actual document in hand and down a video link, and you'll have to do them all again. So what this is a temporary expedient that allows you to rent properties out during COVID without necessarily having to see people, and then catch up later. That said, there are obvious massive flaws in this, because you're still going to have to hand the keys over. So if you've got to hand the keys over, you might as well just do the right to rent check at the same time. And of course, it's just extra work. You're going to have to go do the whole thing twice. So I have some doubt as to whether this is really happening. But Gareth, I think, will know more about what's actually going on the ground.
Perfect. Thanks, David. And so, Gareth, what are you seeing on the ground? Are people taking advantage of the temporary measures? And is there any change in the risk profile for letting agents taking advantage of these temporary measures?
I think it's a real mixed bag, Raj. I think initially, when we saw lockdown, obviously the temporary measures were helpful for agents who couldn't see tenants, wanted to prepare the tenancy in advance, etc. Now I'm not so sure. I think it's a real mixed bag. I think tenants or agents, sorry, tend to go back to the tried and trusted method, obviously with the issues of social distancing, etc. But as David says, they're handing the keys over anyway. I think that in the main, agents are carrying out the checks as they would do traditionally. In answer to your question about risk profile, the risk has to be greater, has to be. If you've not got the applicant in front of you, if you've not got the document in hand, the ability to check that document and the checks that are recommended with the passport in front of you, of course, the risk of impersonation, the risk that that document isn't genuine is going to increase. People need to be vigilant. People need to understand that there is still the onus on them to make sure those things don't happen, even if it is a video link, even if the document isn't in front of them. And that's difficult. The other final point I would make, which is an important part of the legislation, is quality of documentation. Through the fact that we do right to rent checks through our referencing, we see some, let me call them, awful quality of documents that people have taken for right to rent purposes. And I think it's important when you're not the one copying the document, you've just got the tenant sending you, is that you still stay vigilant on the quality of that document. The legislation's quite clear. It talks about a good, clean copy. So if you're storing on file as your statutory excuse a passport which can't be read, cuts half of the bottom off, has got a lot of light on it, a glare, all the things that we talk to agents about and train them on. You need to be wary, and you need to be making sure that you're accepting a document via the tenant or prospective tenant, which meets the requirements under the legislation.
Yeah, this is a problem actually. I actually do have in practice, because of course as a solicitor we've got to get people's ID before we start work, and that's been a problem recently. We're accepting ID that's been sent by emailed photograph, which is often taken on a mobile, but we do encourage people to use Microsoft Lens or Google Lens, or one of the other products that's designed to help you take scan quality photographs on a mobile, because otherwise you could end up with bits chopped off, or it's completely illegible because of shine or reflection. So agents should really try and pick a product. I mentioned a Microsoft product, but other products are available, and try and pick something that they recommend to people to use to send them decent quality pictures.
Brilliant. Thank you both very much. Moving on to the next topic, which is possession claims. So how do you recover possession from a tenant who does not have a valid right to rent check? David.
So this situation is sort of unchanged since the Immigration Act 2016 came into effect. So what that did is basically said that if you receive notice from the Home Office that a person, well, first things first, if a tenant doesn't pass a right to rent check, you're supposed to report them to the Home Office. And that's all you're required to do. Once you've done that, you've fulfilled your obligation. What the Home Office can then do is provide you, and you can ask for this, with a notice of letting to a displaced person. Once you have that in hand, you are required to seek to end the tenancy. Now, if everyone in the property is there illegally, you are entitled to simply bypass the courts, serve them with a specialised notice, which is I think it's called Section 33D notice, enclosing a copy of the Home Office's notice of letting to a displaced person, and then you can simply go straight to a High Court enforcement officer, a sheriff, and they can just throw the person out without any court orders or anything else. So that the Home Office's notice, in effect, is enough to bypass the process. If you don't want to do that, or if only some of the people in the property are there without the right to rent, then your options vary. You can either serve Section 21 notice, the Home Office will accept that, and provided you do that promptly, and it's going to get the person out reasonably promptly, then they're prepared to accept that. So if the problem with that at the moment is the guidance says in the next 3 months, and it's of course not possible to serve a Section 21 notice for the next 3 months. So it's uncertain what their view is on that. Alternatively, you can serve a Section 8 notice citing grounds 7b, but you will have to bear in mind that at the moment, Section 8 notice citing grounds 7b has a different notice period, and that it is now 3 months as opposed to the original notice period of 1 month. It went up to 3 months. Other notice periods went up to 6 months. This one was held at 3 months, so it's shorter than other notices, but not as short as it could be. And then if your tenancy falls outside the Housing Act 88, then forfeiture clauses are automatically tweaked, and you have a right to forfeit a tenancy that's not protected by the Housing Act 88 for breaches of the right to rent once you've been served with a notice. But the starting point for all of these things is the notice of letting to a person without proper right to rent, and that has to come from the Home Secretary. As I said, you can ask for it at the time you report them, but you have to report them first. In general, though, you're not obliged, short of that, to simply evict people who don't have a right to rent, although you may well want to do so, which is why the Home Office has a process to ask for a notice.
Thank you very much, David. We're getting quite a few questions in. Just as a reminder, if you have any questions, thoughts or feedback, please put them in via the GoToWebinar box on the right-hand side. One of the questions that's come in is about changes to notice period. So we have done a separate webinar where David very kindly spent, I think it was 45 minutes, talking through the changes, the most recent set of changes to notice periods under Section 8 and Section 21. That's available via the Fixflo website under the webinar section. And within it, we talk about right to rent, but also all of the other grounds on which possession may be sought. Moving on to the next section of today's webinar, other recent changes. So what is the background to other recent right to rent changes? Gareth, would you like to kick us off on that, please?
Yeah, sure, Raj. I think apart from preparing for the change for EU nationals, quite frankly, what we're seeing here with a lot of this new guidance and legislation is the government fundamentally playing catch up, tying up a lot of loose ends, formalizing a lot of announcements that have been made over the last 2 or 3 years. When we kicked this all off in 2014 with the pilot scheme in the West Midlands, what we were saying to people, it was quite clear that this had just followed right to work legislation. They had taken right to work legislation piecemeal and put it within the private rented sector and tried to mirror it within right to rent. It's why a lot of it doesn't fit, if I'm honest. And what we've been seeing ever since is the government playing catch up. So you see some of the things that have been announced and will start early November. Introduction of the short form birth certificate and adoption certificate. That was entered into right to rent legislation, right to work legislation 18 months ago. So you've got this bizarre scenario which we've had over the years where people can have the right to work but not be able to produce documents to prove right to rent, and that's frustrating. You have agents who've had people entering the country with documents, going through borders, going through border control, proving the right to work, rocking up at a letting agent and not being able to prove the right to rent just because the right to rent legislation is so far behind everything else. And I think that's where a lot of agents' frustration comes from. A lot of them understand why they're doing what they're doing and best practice, and it's a way to mitigate risk, etc., and checking ID, which, by the way, a lot of them historically did prior to the right to rent legislation. But I think there are frustrations there, and hopefully we will now see right to rent and right to work actually mirror each other a lot more closely, and we won't have those lags and those documents which have been out there for years, which people are trying to use, which aren't covered by the checklists and the legislation.
Thank you, Gareth. And David, I've heard about some changes to documents and processes very recently in that. So are you able to step through those, please?
Yeah, so there's a couple of things going on here. As Gareth's already saying, some of this stuff was stuff the government had already done. So the one thing most interesting, or one of the most unusual changes is around what the government cheerfully calls B5J SSK nationals, which I just love as an acronym, so I just had to wheel it in there. But it stands for Big Five, Japan, Singapore, and South Korea. So B5JSSK. We are the only country in the world who uses this acronym. If you type it into Google, it will only show up in relation to the Home Office. No one else uses this phrase. So these countries are the Big Five, which obviously is the UK, but obviously UK nationals don't need to sort out their right to rent status, not a problem, so we can skip them. So the other countries in the Big Five are Canada, United States, Australia, and New Zealand. Japan, so the J, Singapore, South Korea. So people in those countries have been allowed recently to enter the UK essentially on an online visa using the electronic passport gates at various airports. So that the special gates that you stare into a camera and it reads your retina patterns and all the rest of it. And they can come into the country for 6 months. Essentially on a visa-free basis. The government had cheerfully turned around and said landlords were entitled to assume that those people had a right to rent, and they did this about 6-7 months ago, but it was completely illegal because the code of practice is the thing that tells landlords what they are and are not allowed to do, and they'd never updated it. So what we're really doing here is updating the code of practice so that it actually reflects something that the government's been telling landlords they can do for ages. So what this means is if someone comes to you with a B5J SSK passport and also shows you evidence that they have entered the country inside the last 6 months, and that can be a boarding pass from a flight that landed inside the UK inside the last 6 months, even an electronic boarding pass on their phone, then they will have a right to rent under the new regime. And of course, a right to rent for 12 months, or a 12-month minimum before you have to do a recheck. So you can essentially rent to them and not worry about it. Now in part this is highly connected to our post-Brexit plan to enter into fantastic trade agreements with big countries around the world, and countries like Japan and Canada and South Korea are high on our list. And so the idea of the B5J SSK thing is that floods of business people will want to come to the UK, and we should therefore ease their passage through the airports and also allow them to rent property to do business here for several months, because and to shop and do all the other exciting things that they'll want to do. So that's kind of what this does. How much difference this will really make is uncertain. I've not actually heard of anybody making use of the B5J SSK powers since they were first mooted. So all that's happened is that we've formalised something that already existed.
Thank you very much. In fact, as you just touched on it, I'm going to jump to a section which I think we're going to cover off in a moment anyway, which is what happens post-Brexit, David. So do you have any insights on that?
Well, nothing. In first, because the Immigration Act 2014 is a freestanding system. So the fact that we've left the EU doesn't mean that EEA nationals won't still have a right to rent. Assuming the government lets them into the country, and that's a separate issue, EEA and Swiss nationals and EEA and Swiss residents will continue to have a right to rent until such time as we alter the Immigration Act 2014, which sets up the right to rent. What the government has indicated in producing this code of practice, and there's kind of part of this is undoubtedly connected to the political factor of the EU negotiations, is that this regime will last until we get to 2022. So there was originally going to be a new immigration bill in 2021, and the right to rent was going to be substantially altered at that point, we were being told, without any fanfare. in the code of practice. We're now being told that this code of practice will be enforced in 2022. So it looks like this big flag immigration bill is being pushed off by a year. And undoubtedly what the government's going to try to do is link right to rent with our future putative points-based immigration system. And so EU nationals presumably will have no greater status in terms of their entry into the UK and their right to rent than people from Japan, for example, or such other countries as we do fantabulous deals with for trade and travel.
Thank you very much. And Gareth, just turning to you before we come to the audience questions, there are quite a few that have come in. My colleague Remy is compiling them into an order which hopefully bears some relation to the order in which we've gone through the topics today. But Gareth, I've heard about an online checker for right to rent. Can you give the audience an overview of what that is and how it works, please?
I shall try my very best. So I think we're back to right to work again. I'm going to be very, very repetitive. Both yourself, Raj, and David, we've been at Lettings Industry Council meetings where we've had presentations from the Home Office who give a little bit of an insight to what this online checker may look like. There's nothing available online at the moment. We've got some guidance through the new code of practice, but again, we're looking at right to work and what the right to work checker looks like. And I think it's just going to be, the same. So the right to work checker has been in place online since the 14th of December 2018. And what we're going to have on the Gov.uk website is you're going to have a link which will very simply say view a tenant's right to rent details for an agent. It's not going to be for everyone. It'll be for those applicants, those prospective tenants who have one of three things: either a BRP, which is a biometric residence permit, a biometric residence card, or, and I think this is where the crux of this all really lies, is a status issued under the EU settlement scheme. So those people from the EU who have been quite proactive and have obviously applied for settlement way ahead of time. So anybody with one of those three things can go online, access their online profile. That'll be, again, another link which will basically say something along the lines of prove your right to rent to a landlord. They obtain a share code. That share code is then given to the agent along with their date of birth. The agent can then access the applicant's profile. They must still satisfy themselves that the photograph that they're going to access is a genuine likeness. So pre-COVID or post-COVID, that means having the person in front of you still. This isn't going to get away from the fact that you need the person in front of you while you're accessing the details. Obviously, if we're still within the COVID regime, it's going to be having that person on video and make sure that it's a true likeness. And you'll then store the details as you do now for the duration of the tenancy, plus a term of 12 months. The government's saying at the outset that this won't be mandatory, and you can't make it mandatory. You can't say to an applicant, I need your share code, I'm not checking your right to rent. You can still give the option of, let's call it the old regime, where the checks are carried out by looking at documents. But my guess is, and my opinion is that at some point in the near future, this is where the government wants this to go, is that the checks will be done online. And I think there is a long-term vision that migrants will be asked to almost self-enroll their biometrics. And those details will be available for agents to check. But just to reiterate, this isn't going to help for UK applicants with UK passports. This isn't a document checker. This isn't to validate documents that you already have. This is for a certain set of applicants where you can go online and check their immigration status and obtain your statutory excuse.
Thank you. And David, I know that we normally would now go into GDPR and potential personal data protection and the like, but given the number of questions that we've had in, hopefully you'll be okay with me moving on, because They're coming through thick and fast. If you've got any more, we want to make sure that we're dealing with as many of these as possible. The first is directed to David. David, could you please sum up the changes that are coming into effect on the 2nd of November? Just as
yeah, I mean,
wrap up on that, please.
Three very quick things then. The first is that there's been a slight tweak to documents. It won't affect most people. It just simply allows you to use short form birth certificates. Most people probably don't even know the difference between a long form and short form birth certificate anyway, and they're rarely provided. There is making lawful that which was already there, which is the B5J SSK national thing. So in fact, some people are probably already doing it if you were doing that. And the third thing is basically enabling the online checker, which technically will be in effect from the 2nd of November, but it doesn't actually exist yet. So don't get too excited. It will become available, but this code of practice puts that onto a proper legislative footing.
Thank you. And so in roughly the order in which we spoke about things, we've had a couple of questions in about the need to evidence the conversations with tenants. So ought agents be recording the conversation on Zoom or Teams or GoToWebinar, one of the many different video conferencing systems that are available, and storing that? So Gareth, what's your view on recording the conversation where the tenant is also showing their passports or equivalent?
I would say there is no need to. I mean, why take the risk of storing something that you don't have to? I think the actual legislation, or certainly the temporary legislation, asks that you take a copy of the document and check the person's likeness. You don't take a video of when you meet somebody face to face now. I don't think there's a necessity to actually record and store a video of your Zoom call or whatever method you may be doing that. I think it's unnecessary. And obviously there are.
If under the new temporary COVID regime, the person is required to send you a scan of their document by email. You don't see the document and view the document because they're holding it up to a camera. They must send you a scan, and then with that scan, you then have a conversation with them on Zoom where they will also hold up the document and then show you their face. But the scan is the document that you're endorsing.
Perfect. And that, I think, deals with the next question that we had in. One of the follow-ups to that question was, since the changes were introduced, we've moved in about 2,000 tenants. Will we need to arrange for all of them to visit our offices in the future to present original documents?
If you've used the coronavirus bypass mechanism to do those checks, then yes, you will have 8 weeks from the end date that the Home Office will eventually announce to recheck all of those people live in your office with their original docs. Obviously, how you're going to get them to turn up when you have almost no hold over them is a matter I can't really answer.
And not being able to get hold of them, I think, ties into the next question around follow-up checks. So if you took advantage of the temporary measures and then have to do a follow-up, but the tenant at that time is no longer in the UK, for example, if they've gone overseas to apply for a visa, or there's another reason why they're not available, what is the process there, to the extent that there is a process? So you're now within the period where the temporary measures have been stopped, and you are required to have the in-person check, but the tenant continuing under the tenancy is no longer in the UK for a reason. Is the guidance?
You've got 8 weeks to do the checks. That's a hell of a long absence, given that they're not supposed to be absent from the property for more than 28 days in most cases under the tenancy agreement. If you can't verify them, ultimately you're going to have to report them to the Home Office. That's the long and the short of it. I mean, that is the process, such as it is.
And just to sort of pick up on that, because that was a specific question. So if a tenant, for example, refuses to attend your office or to be validated in person during that 8-week period, the letting agent would be obliged to report them to the Home Office as if they had not.
Yeah, I mean, I would push you about it and say we're required to do this check, and if you don't do it, we will have to report you to the Home Office, and at that point, you're going to have to report them. Yes.
I think this next question strays into an area not related to right to rent, but I'm going to ask it in any event in case you've got any views you would like to share. So one of the audience members has been completing video calls to check on guarantor IDs as they don't live in the area. When the temporary changes are lifted, do we need to see the guarantors in person to see their documents?
No.
Guarantor checks have nothing to do with right to rent.
Thank you. Moving on to, sorry, the questions are still coming through, and my colleagues are doing a great job of sort of summarising them into themes for me. So from the 2nd of November, the factual scenario is if a Japanese national wanted to rent from us a week after they arrive in the UK, can you only grant an 11-month tenancy on the basis that the rule from the 2nd of November allows 12 months from date of entry into the country?
No, and in fact, you're not allowed to do that, because that would be a discrimination on the basis of right to rent. The right to rent discrimination process says that you have to grant them whatever tenancy you would grant anybody else. So you have to do it on the basis that, and this is kind of the problem with the right to rent, is that it requires you to discriminate but not discriminate at the same time. You should grant them exactly the same tenancy you would grant to anybody else, and then assume that they're going to sort things out.
Just a point on the BJ5 SSK documents. We see a lot of these through our London agents. I'm not saying it's just a London issue, but obviously it's the makeup of tenants in London. We see a lot of these applications, and the practical advice I've given to my agents, and I know a lot of them do this, is if you're having a conversation with these people or by email before coming to the country, ask them to get the passport stamped. It stops the problem in its tracks because you've got right to rent. The other thing that isn't helpful with the new legislation is the government have tagged on to the end of the documents that you can ask for is any other documentary evidence which establishes the data arrival in the UK in the last 6 months, which again throws it open to them trying to give you something random when it says any other documentary evidence. I mean, we could all go to any airport in the country and go to an arrivals lounge and find something on the floor, which is potentially any other document to show that you've just entered the country, whether it be a piece of a boarding pass or an email, etc. So I don't think they've helped themselves in adding that to the legislation.
I think the next question is going to go back to Gareth as well, which is, can you use an external company to visit the tenants to do the right to rent check on your behalf? So can you outsource the right to rent check?
My understanding is no. It can be outsourced. I mean, you're into the terms of agency agreements, and I'm sure David will be able to give you more advice on this than I am. But from a practical sense, obviously, the landlord and agent relationship is cemented in law, and it can be passed on through your terms of business, through your agreement with your landlord. Actually doing that to a third party, I'm sure David can give us a way that can be done, but it's got to be messy. David?
Yeah. It's a problem because the Home Office doesn't really understand the law of agency properly. So the legal obligation to do a right to rent check is the landlord's. If the landlord has agreed with his agent in writing that the agent will do it on his behalf, and the law distinguishes here between initial and follow-up checks, incidentally, so it would have to be both of those, then it becomes the agent's responsibility, and the landlord has a defence that his agent didn't do his job. Now, the problem from the Home Office's perspective here is they're saying that the agent can't employ a sub-agent to pass on their responsibility, which is true. An agent has no power under the law to pass on their responsibility. But there is no reason why the landlord couldn't contract with a separate agent who was their right to rent checking agent And so it'd be open to letting agents to bring forward a third party that they were in a business relationship with and say to the landlord, contract with this guy over here, who is your right to rent checking agent, and I'm your property agent. So there is a way of doing it. It is untidy, but it is possible. And there are people out there offering right to rent check businesses. There's a network of solicitors, I think, doing it. And one of the reasons to think about it, I think potentially, especially post-Brexit, is if you could contract with someone who's got an international set of offices, then you could actually do some of these checks before people had even entered the country. And that has potentially a value.
Yeah, of course, what you can do as well is you can certainly use a third party to look at whether the document's valid or not, to tell you whether it's a genuine document. And I know obviously a lot of agents, whether it's referencing companies or whether it's other third parties, actually go through that process. So can they take away your obligation and your need to gain the statutory excuse? No. Can they validate the veracity of the documents? Then yes, certainly third parties can do that.
Yeah, I think there's an important distinction here between giving agents comfort, which there's a number of services you can get, which for most agents is probably enough, and actually replacing the agent's responsibility, which is theoretically possible, but a bit of a pain.
Thank you. I'm just going to follow up. There are a couple of questions that have come up in different guises, so I'm going to do my best to summarise them as best I can. So the first is, can you tell a tenant that you're going to report them? So when we talked about earlier the report to the Home Office, can you or should you tell a tenant that you are due to report them for breach of right to rent legislation?
Yeah, you can tell them if you want. This is not like money laundering where there is a specific rule that says you are not allowed to tip off. There is no offence of tipping off in relation to the right to rent. So yes, you're perfectly free to tell people that you're going to report them. Gareth, I'm going to report you for the right to rent violation later. There you go.
And what about rechecking the right to rent? Are there any changes, or is everything as it was previously?
There are no changes, save for that you might be able to do there'll be slightly different documents available to you to do the check, and of course potentially you might be able to do it online, depending on who the person you're rechecking is and whether they are on the online system.
Sorry, a further question. So I've just found another section of questions because they've been reorganised. If a tenant has left the property, so they were checked under the temporary measures, and between the tenancy commencing and being checked under temporary measures and the date on which temporary measures are stopped because there's a vaccine or something, the tenant is no longer in the property, do they still have to be checked? So is there any obligation if the tenancy is not persisting, say a 3 or 6 month tenancy?
Well, that's a bit of a problem, isn't it? The temporary measures don't even canvass that scenario. I mean, in practice, in technically, yes, in practice, it's just not going to happen, is it? So not really.
Thank you very much.
They're not likely to be too fussed if they're not there.
Really grateful for you, David and Gareth, for giving us your time, your thoughts, your insights, and for everybody attending today. We'd love to get your feedback on today's webinar. So as you leave, please take a moment to give us your thoughts. Let us know whether we're hitting the mark or not, and whether there are any other topics that you might find useful. If you have any general feedback on our webinar series, please email research@fixflo.com. We have run to time, so thank you very, very much for attending. Thank you, Gareth. Thank you, David. And I hope everyone has a wonderful day. Cheers.